Hey everyone, today we're going to talk about promissory estoppel. For those of you who are not living in Singapore, don't worry. If you are living in a country that practices English law, the principles are the same. Now, what is promissory estoppel? The doctrine of promissory estoppel prevents a person who has promised not to enforce his strict legal rights from going back on his promise when it is unjust to do so. In the English case of Thomas Hughes and the directors of Metropolitan Railway Company, the court held that when parties who have entered into definitive and distinct terms involving certain results, certain penalties or legal forfeiture, afterwards, after the contract has been entered into, by their own act or by their own consent, enter into a course of negotiation which has the effect of leading one of the parties to assume that the strict legal rights under the contract will not be enforced or will be kept in suspense or held in abeyance. The person who otherwise might have enforced those legal rights under the contract will not be allowed to enforce them, where it will be unjust, inequitable, having regard to the dealings which have thus taken place between the parties. Now, in Singapore, the Court of Appeal in this case called Chuan Hong Petrol Station and Shell Singapore supplemented and said that the doctrine of promissory estoppel does not seek to contradict, vary, add or subtract from the terms of the contract. In fact, it presupposes and recognizes the existence of the terms of the contract. It only operates, the doctrine of promissory estoppel, it operates to prevent a party who has the benefit of terms of the contract from enforcing them if the conditions for the doctrine are fulfilled. What are the elements of promissory estoppel? Number one, the person who is estopped from enforcing his strict legal rights has to make a representation. Representation could be orally or in writing, or conduct amounting to a representation, which is intended to induce a course of conduct on the part of the person to whom the representation is made. Second element, an act or omission resulting from the representation, whether actual or by conduct, by the person to whom the representation is made. Third, detriment to such person as a consequence of the act or omission. What is detriment? Justice Stephen Chong in the Singapore case of Lam Chi Kin David and Deutsche Bank explained that the term detriment may be understood to mean incurring expenditure of money and time, incurring a liability, change of position, or detriment or deprivation of a benefit. Let me give you an example of a case. I believe some of you may have watched a video I did earlier. It was a landlord-tenant dispute. Basically, the landlord had entered into 4 tenancy agreements with the tenant. The tenant was my client. Each of the 4 tenancy agreements contain an option to renew clause. During the first 3 tenancies, when my client, the tenant, exercised the option to renew by email through the real estate agent, the landlord extended the term and renewed the tenancy. However, during the 4th tenancy agreement, even though there was an option to renew, she refused to grant a new term under the tenancy agreement, despite the option to renew clause being an unconditional clause. So of course, my client, the tenant, asked me to sue her for specific performance or damages in lieu of specific performance. So one of the submissions, the arguments that I submitted to the court was that during the course of the 4 tenancy agreements lasting 8 years, the landlord had made representations throughout these 8 years that all communications and notices between the parties were to be made through the real estate agent by email, text message, or in writing. So her defense when she was sued was that the fourth renewal notice was not sent by registered post. There was a clause at the bottom of the tenancy agreement which says something along the lines that all notices shall be sufficiently served if sent by registered post to the address of the landlord or the tenant. So that was a sole defense. Because it was not sent by registered post, it was sent by email. The notice to renew was not valid, so she was not liable. So one of the other submission I made was that the landlord had never once requested or demanded that the plaintiff communicate with her or give notice to her by registered post under the registered post clause. So in other words, the landlord had made representations to my client, the tenant, during the 8 years that all notices and correspondence was to be made by email or text message or voice calls through the real estate agents. Therefore, it is unfair for the landlord during the last tenancy agreement to enforce her strict legal rights under the tenancy to insist that my client, the tenant, gave the renewal notice by registered post. So, what is the detrimental reliance in this case, the landlord-tenant case? The detrimental reliance is that my client, the tenant, was not able to enjoy the benefit of an additional 2 years under the option to renew clause. The last point I want to make on promissory estoppel is that the doctrine of promissory estoppel can only be used as a shield, not a sword. In other words, you cannot sue someone, it's not a cause of action, you cannot sue someone under promissory estoppel. You can only use it as a shield, as a defense, when someone sues you under a contract, for example, breach of contract. You use this doctrine, promissory estoppel, as a shield, as a defense, to say, no, you promised me this, okay, although the contract says this, but you changed your position, you said you will not enforce the rights, so I'm using it as a shield, you cannot sue me for it. So that's all I have to say about promissory estoppel. If you like this video, please click like and subscribe. Thanks for watching.